All right, let's set the scene. You're a junior lawyer, fresh in the practice. An order from a revenue officer lands on your desk, and it's bad news for your client. Across the room, your senior partner is looking at you, and they want a plan. This happens to every lawyer, and believe me, how you react in these first few moments can make all the difference.
The pressure's on, right? You know there are options, but which one is the right one for this specific case? Do you file an appeal, or is this a situation that calls for a revision, maybe even a review? Getting this first step wrong could jeopardize your client's entire case. So what's the play? What's your move under the Chhattisgarh Land Revenue Code?
I want you to think of the Land Revenue Code as your personal toolkit. It's not just a dry book of rules. Inside, you've got three main instruments designed to challenge an order that's gone against you: appeal, revision, and review. Each one is a different tool for a different job. Knowing which one to pull out and when, well, that's the art of being a great lawyer. So let's open this toolkit up.
Okay, first up, and the tool you'll use most often is the appeal. 9 times out of 10, this is going to be your go-to, your primary way of fighting the substance of a bad decision. Now let's get one thing straight right away. An appeal is not a favor someone is doing for you. It is a statutory right. That means the law itself says your client is entitled to a fresh pair of eyes on the case, a higher authority to see if a mistake was made. And the goal is simple: fix the errors, whether they're about the facts of the case or the law that was applied.
So, where do you take this appeal? Well, you don't have to guess. Section 44 of the code gives you a crystal clear roadmap. It's a ladder. If a TCUDAR made the order, you climb one rung up to the subdivisional officer, the SDO. If the SDO made the order, you go to the collector. From the collector, you head to the commissioner. And from the commissioner, the final step on the ladder is the Board of Revenue. You can't skip steps. You gotta climb it one rung at a time.
Look, knowing where to file is only half the story. The other half, and frankly, the part that can really trip you up, is knowing when you have to file. These deadlines are non-negotiable. You miss one, and that statutory right we just talked about, it can just, poof, disappear.
So let's talk numbers. For the first two rungs on that ladder, appealing to the SDO or the collector, Section 47 gives you exactly 45 days. That clock starts ticking from the date of the order, and trust me, 45 days goes by in a flash.
Moving up the chain, if you're appealing a collector's order to the commissioner, the code gives you a little more breathing room. You've got a 60-day window to get your paperwork in. And finally, for the top of the ladder, the appeal to the Board of Revenue, you get the most time, a full 90 days. So remember these numbers: 45, 60, 90. They are absolutely vital. Your client's case depends on them.
Okay, but what happens if an appeal isn't the right move? Or maybe the deadline has passed? Well, let's pull out the next tool: revision. Now, this is a totally different animal. It's not about relitigating the facts. It's more like asking a higher-up to step in and supervise.
The two key phrases here are discretionary power and not a right. Unlike an appeal, the higher authority doesn't have to hear your revision. They can choose to look at an order, but they're only looking for major screw-ups. Like, did the lower officer act completely outside of their legal power? Was there a massive procedural error? Revision is your emergency brake for when the legal process itself has gone off the rails. Our third tool is the most specialized of all. With a review, you're not going up the chain of command. You're actually going back to the very same person who issued the order and asking for a do-over. Yeah, you heard that right. Under Section 51, you ask the same officer to reconsider. But, and this is a huge but, you can't just make the same arguments again. The bar is incredibly high. You either need to bring in some game-changing new evidence that you simply couldn't have found before, or you have to point out a mistake that is so obvious it just jumps off the page. An error apparent on the face of the record. So that's the theory, but how do judges interpret these rules in the real world? Case law is where the rubber meets the road. It shows us how these tools actually function in practice. Let's see what the courts have to say. This table right here, this is your quick and dirty guide. Just look at the differences. Appeal, it's your right. It goes to a higher authority, and it's for any kind of error. Revision, it's discretionary, also goes to a higher authority, but it's only for jurisdictional or procedural blunders. And review, it's a limited remedy, and it goes back to the same authority for really obvious mistakes. Print this out, stick it on your wall. And you don't have to just take my word for it. In Chandrasekhar Sahu versus the state of Chhattisgarh, The High Court came out and said it loud and clear. They called the right to appeal a legal entitlement. That's a powerful phrase. It means the system is built on the idea that no single officer gets the final say without someone else checking their work. Now, for contrast, look at Madhav Prasad versus the Board of Revenue. The court here draws a very sharp line. Revision is supervisory, not appellate. The higher authority can't just step in because they would have decided the case differently. They can only intervene if the lower officer broke the rules of the game, if they acted without jurisdiction. This is so important for managing your client's expectations.
All right, enough theory. Let's get down to brass tacks. That adverse order is sitting on your desk cooling. What are the very first things you do? Here's your action plan. The absolute key here is to be methodical, not to panic. First thing, before you do anything else, write down the dates. The date on the order, the date you got it. That starts your clock. Next, who signed it? Tehsildar, SDO, that tells you where you are on the ladder. Then pull out Section 44 and confirm who you're appealing to. Calculate that deadline. Is it 45, 60, or 90 days? Get it in your calendar. Then you can start drafting your arguments. And whatever you do, don't forget to attach a certified copy of the original order. Simple steps, but they are absolutely critical. So there you have it. You have the roadmap in Section 44. You have your stopwatch with the deadlines in Section 47. And you have your specialized tools for unique situations in Sections 50A and 51. The code gives you everything you need to mount a strong challenge for your client. The toolkit is open. Now it's time for you to get to work.